In this video, I want to talk to you about frustration and the common law. Now, the doctrine of frustration is largely centered around case law. Only a very small part of it is governed in the Frustrated Contracts Act 1988, and that act seems to more focus about money remedies and compensation and where the losses lie, that kind of thing, whereas genuinely establishing is the contract frustrated, if how so, that kind of nature of it and what would be the consequences is mainly governed through case law. So it is a fact-sensitive concept in law, and it depends on the terms of the contract, the effect of the frustrating event, not the nature of it. So that's a key distinguishment, because you don't care like whether it's a fire or a crash. The actual event is not important. It depends. Has this affected the contract? Then yes, because sometimes you can have the same frustrating event, but yet in some cases it is frustration and some it's not. So an example is in Crell and Henry, the coronation of the king, which was postponed because of his ill health. When the guy rented a room for the purposes of seeing the coronation, that contract was frustrated because the frustrating event, the postponement of the coronation, made it impossible to perform the contract, which is to give the guy who has paid to view the coronation. Whereas exactly the same event in Hearn's Steamboat had a completely different event. This is where there was a guy, he had a boats company, used to take tourists around, and part of seeing the different sites was to see the coronation. Now, because the coronation was postponed, that did not mean the contract was frustrated, because actually they could still fulfill their duties of showing all the other sites that they had to see and giving the tourists a flavour for the place, and the tourists got their boat ride and they got to see the sites. So this is a key example. The problem with the common law is some critics say it's a bit harsh, because you have the losses lie where they fall. So you say, okay, frustration happened here, so from here on the contract does not apply. Well, you paid a deposit. Well, oh well, we can't do anything about it. And this changed with the Fibrosa case. Now, what happened in the Fibrosa case is the defendant was in a contract to supply the plaintiff with machinery. The plaintiff, as part of the contract, paid a deposit of £1,000. Now, there was a frustrating event. I think it was a war or something. I'm not entirely sure, but I can just double check because I have it written somewhere here. Yep, there was a war, and because of that, the transaction could not be completed. So the courts actually allowed for that £1,000 deposit to be reclaimed, because actually there was a total failure of consideration. And as you'll see in some of my later videos, sometimes people benefit not financially but in other ways. And if the other party is at total loss, then there you allow some kind of remedy. So here the party had gained £1,000 yet gave nothing. It's a total failure of consideration, and thus the £1,000 was reclaimed by the plaintiff. So what we need to understand with the Fibrosa case also is that the Frustrated Contracts Act 1988 arose out of the Fibrosa case, because it was setting out where it's fair for people to reclaim expenses or losses and where it's not. Thank you.